All right, welcome. Good morning. Man, it is good to be in Phoenix, Arizona, isn't it? Phoenix, Arizona at the end of the year. I don't know about most of you. It's about 30 degrees in Utah, and some of the rest of you, I don't know where it's like, but man, it is good to be here. Thank you for being here. Thank you very much for being here. We have work to do, and nobody else is going to do it. Nobody else is coming to the rescue. So, we keep thinking that maybe somebody will step up, maybe Congress will wake up and have a V8 moment and they'll just get it right. It was never intended to be that way. When I've been traveling the country a bit, speaking with Rick Green, Patriot Academy, those of you that know Rick, and we've been out teaching and getting people fired up on what it means to be sovereign in their government again. And usually we speak by the end of the day, and I'm the warm-up act for Rick. But by the time we get up, people have talked about all sorts of things and the problems and the concerns, and everyone's ready to figure out where do we go from here. And typically I'll step up. I don't have the slide. I wish I did. I'll show you after. We're going to do the grandparent exchange photo things after because, grandparents do that sort of thing. But I'll get up and I'll say, we've talked about all sorts of problems in government today, but we've not talked about the most critical problem, the problem of the greatest concern, the problem that is weighing on us all that we need to deal with. And then I put up a photo of my grandson in the pantry, and his panda bear is about 5 shelves up, and he's got flour all over him and all over the room and all over everywhere. And that's what my daughter finds on any given day when she wakes up, because about 2 o'clock in the morning, my little grandson roams the house, and she just never knows what she's going to find. And 2-year-olds, we know that's what 2-year-olds do. 2-year-olds they act like 2-year-olds. And we love them. We need them. We can't live without those precious 2-year-olds in our lives. And we can discipline them. We can teach them. We can shake our finger at them. We can put them in timeout. And they're still going to get in trouble. Because that's just what 2-year-olds do. It's not a bug, it's a feature. That's what a 2-year-old does. And 2-year-olds are pretty much just like government. Should say government's just like a 2-year-old. We need it. We love it. It's critical. It's important in our life. And if we don't watch it every single minute of the day, it's going to get in trouble. It's not a bug, it's a feature. The framers knew that. They knew that government grows, that government expands. In fact, I love Reagan. We get so many Reaganisms today, but Reagan said it's a mathematical truism that as government expands, liberty contracts. And we know that government grows. That's why they gave us the Constitution. That's why they built checks on top of checks on top of checks. They gave the people, all power comes from our Creator, and we gave a limited speck of our governing power to government. And of that speck, it was balanced between 2 governments, right? The government far away, less accountable, less transparent, few and defined powers. Government close to home, more accountable, where the people can actually keep an eye on things, numerous and indefinite power. And then that speck of limited governing power that was balanced between 2 governments was then further divided between 3 branches of government. That's all broken down now, because all we teach in school is executive, legislative, judicial at the federal level. And is it any wonder if we only teach 15% of the checks, we're 85% off base? So this is our job. John Dickinson said, it'll be the state's own fault if you allow the federal government to interfere in the things of your jurisdiction. And to just kick things off, I want to read a quote. I was having lunch with Chris Stewart, our member of Congress, who resigned recently. And we were having lunch, and I was talking to him about a Jefferson quote. And Jefferson just, you remember President Kennedy when he had all of the Nobel laureates in the White House, and he was speaking to them, and he said, this is probably the greatest assembly of intellect the White House has ever seen, except for the possible exception of when Thomas Jefferson dined alone, right? He saw what was coming. Here's what Jefferson said. He said, I'm not among those who fear the people. They, not the rich, are our dependents for continued freedom and to preserve their independence. We must not let our rulers load us with perpetual debt. We must make our election between economy and liberty or profusion and servitude. If we run into such debts as that we must be taxed in our meat, in our drink, in our necessities, in our comforts, in our labors, and our amusements, for our callings, our creeds, as the people of England are, our people like them must come to labor 16 hours in the 24, give earnings of 15 of these to the government for their debts and daily expenses, and the 16th being insufficient to afford us bread, we must live as they do now on oatmeal and potatoes and have no time to think, no means of calling the mismanagers to account, but be glad to obtain subsistence by hiring ourselves to rivet their chains on the necks of our fellow sufferers. He went on to say, this example reads to us the salutary lesson that the private fortunes are destroyed by public as well as private extravagance. And this is the tendency of all human government. A departure from principle in one instance becomes the precedent for a second, and that for a third, and so on, till the bulk of society is reduced to be mere automatons of misery, to have no sensibilities left but for sinning and suffering. Then begins indeed the bellum omnium in omnia. That's what we were talking about with Congressman Stewart. War of all against all, which some philosophers, observing to be so general in the world, have mistaken it for the natural instead of the abusive state of man. And the forehorse of this frightful team is public debt. Taxation follows that, and in its train, wretchedness and oppression. That's baked into the cake, unless we predict the future by creating it. That's what we're going to talk about today. We have the opportunity, we have the sovereign power under the Constitution to change that future, if we will. You're first going to hear from Bob Carlstrom, who is the president of the Association of Mature American Citizens. And after Bob, we will hear from Mike Capek, who has been a warrior in this Article V effort and written a book on the subject, Conventions That Built America. And you've got here a panel of folks who have been involved in Stop Inflating the U.S. Task Force to work on the mission of bringing us together as state legislators to use that power that we have to coordinate our power, to focus on Congress to do their duty. If we get to the point of 34 applications, to make the call, to archive the applications. And then you've got organizations such as the Phoenix Correspondence Commission that came out of a 2017 officially called Convention of States to draft rules for a Convention of States. So we already have in the books a set of rules for how we would conduct a Convention of States for fiscal responsibility. Out of that officially called convention came the Phoenix Correspondence Commission to help us understand what Article V is, how we exercise it, how we keep limits upon it, how we coordinate together as states. Next Friday, December 8th, 9 a.m. Pacific, noon Eastern, we have the annual delegate meeting of the Phoenix Correspondence Commission. And if you're not sure that your state has delegates to this officially created Phoenix Correspondence Commission, check with Bruce Lee. Bruce is in the back. Bruce is the executive director of the Phoenix Correspondence Commission. That is a nonpartisan organization. It's a .gov organization that simply exists to help us understand what is Article V, how do we exercise that power, how do we make sure that it's done constitutionally, safely, appropriately. So please get with Bruce and go from there. But now it's my great honor to introduce my dear friend Bob Carlstrom from the Association of Mature American Citizens.
Thank you, John. Well, good morning, everybody. It's so good to be here with you. Really appreciate all that you're doing in the service of your country through your membership in your state legislators. I am here on behalf of AMAC, as the acronym goes on that, and that's the conservatives' alternative to AARP. you have that available to you. We were started in late 2007 by the late Dan Weber, as well as his wife Judy, to provide Americans an alternative to AARP's leftist policies. And we've grown from those two founders to over 2.2 million dues-paying members. And it costs $16 a year to join. It's very expensive, but we can finance it at $1.25 a month with no interest. That said, thank you, Tom. I lead AMAC Action, which was launched in 2019. It was pretty much a paper tiger at that time. And of our membership now, over 380,000 of our members respond to our calls to action on state legislation and on federal legislation. And they do so within 24 hours of getting a calls to action. And we know down to the single digit who's doing it and who's not, because we've built the infrastructure for that. And our mission in AMAC Action is to provide American citizens and conservatives a vehicle by which they can engage in the public process. Because so many people sit there and watch what's going on in Washington and say, God, what can I do about it? Well, you can, and we offer that. And now, since we've been doing that, over 2 million contacts have been made with legislators. Now, we strongly support the use of Article V. And we conduct weekly annual polls of our nationwide membership. And in 2021, 82% of our members said, yes, we want an Article V convention. We support the use of our Constitution on that. And that's up from 61.4% in 2020. So the grave financial threat that was discussed earlier this morning is very, very real. We don't want to become another Venezuela, and that's something to really think about. Thanks to the administration and Congress's inflation fueling policies against fossil fuels and the development of its uses and promoting unbridled spending, the results are very clear to you. You've all felt them in your pocketbook and your checkbook, and all of your constituents have as well. And Americans on fixed and low incomes are really turning to credit cards to purchase their necessities. And credit card debt is going up. Thank you, the current administration. Airfare costs are going. And so absent a whole of government commitment to this, it's just going to get worse. Just worse. And the only way to remove the weight of inflation, is to finally make permanent spending resorts. Now, people say in Congress, well, we can do it. Well, they can't. It's clear that they cannot control themselves. There's little or no congressional control over spending. The Graham-Rudman-Howling Balanced Budget Act of 1985 is like Swiss cheese. It's so full of holes, that they can avoid, doing what they should be doing in the Congress. And then a few years ago, Congress couldn't even adjust their spending by reducing each dollar by 1 cent. They were afraid to do that, and so on it goes. And so now we're looking at a $33.8 trillion debt, almost 34 trillion. And then also look at Congress and the partisan circus that's going on, in terms of the debt limit bills. When I was in the Reagan OMB, those used to come to me and they were in the billions. Now it's just a shrug and it's a political game. And then look at the current appropriations mess in Congress. They can't even pass, as Dave spoke earlier this morning, appropriations bills. There's splits in the House among moderate and conservative Republicans and Senate inertia, where both the Republican and the Democrat leaders seem to want another mega omnibus bill, which is, again, uncontrolled spending. So they can't do it. So we need you to step up and continue to press hard, for the passage of H-Con Res 24. Congress needs to do that. We need to do that because of the erosion, that particularly our constituency, which is baby boomers and Gen X, are really feeling the pinch, particularly those on modest and fixed and low incomes. They're really getting stuck. And so we believe that you are the last line of defense against the Congress and against runaway federal spending. And your constituents are depending upon you. You know, the fear-mongering by opponents of Article V of a runaway convention or nullification, you know, where states say, well, we're not going to take federal money, you know, it's nonsense. It's just fear-mongering and a rhetorical nonsense. Why conservative organizations are doing that, beyond me, unless they're raising money to do it. So anyway, what I've been asked also to address very briefly is Social Security. You know, people are saying, well, Article V is going to vitiate Social Security and they're going to ruin it and all of that. That's nonsense. A fiscal responsibility amendment will not impact Social Security. You know, Social Security is funded by contributions. They don't call it a tax in Washington, they call it contribution. And it goes essentially into an escrow type account. Used to be a strictly escrow account before we pulled it in for budget scorekeeping. But Social Security is funded by the contributions of individual taxpayers and not by federal appropriations. Only the Social Security Administration agency receives appropriations. The levels of Social Security benefits can then only be protected by addressing the core organic legislation itself. Article V doesn't even touch that. So, and that's where Congress, you know, needs to make the adjustments in Social Security to improve its situation. And we've recommended a number of internal adjustments that can still guarantee, you know, COLAs, reasonable COLAs, that we think that can put it on a path to a better forecast. Because otherwise, you know, the 20 to 25% reduction that automatically occurs in 2032 or so, you know, will happen. You know, one such change, you know, that we've looked at, Republicans have looked at, is increasing the full retirement age to 70. But that's very gradual over several almost few years, and goes month to month. And then there are other changes that we can deal with in the organic legislation. I will also say to you, too, that AMAC, we strongly support repealing the tax on your Social Security benefits. That's double taxation. It should not be allowed. Simply should not be allowed. We also want to repeal the RMD distribution requirement. That's the federal government digging into your savings and telling you when you need to take them. So we're there. So, but nonetheless, you know, we're fully committed to Social Security. It's ingrained in our country and embedded in our nation's commitment to seniors. And so, so please, you know, disregard, you know, those that say, that are fear-mongering and say you're going to destroy Social Security, it's going to be a runaway convention, and all that is just nonsense. Those of you who are legislators know what it's like to get a paragraph in a bill approved by all your colleagues. You think that's going to run away when 38 states are reviewing a text? No, you know, but that's nonsense. So just go right back at them and say that. So in conclusion, you know, it's your time and your responsibility to do as the founders wish. You are the core unit of our republic. And we need to convene the convention in the case of fiscal responsibility to protect your children, your grandchildren, your friends and neighbors, and generations to come. So thank you very much.
All right. Thank you, Bob. Before Mike comes up, you have cards out on your desks, and so if you have questions, if you would just write out on the cards, send those up, and we can have those addressed by the panel. Honored to have Mike Capek speak to you now. This gentleman is a citizen warrior that is out there to help you all move this effort forward. Mike, thank you.
Thank you. Thank you for this opportunity to talk to you, and thank you for being here. We're going to talk about a fool's errand, because that's basically where we are and what we've done. The founders gave us a combination of ways of revising the 4,500-word, 7-article Constitution, which is basically just the blueprint of our government. And you make something, you want to be able to adjust it and change it. And they gave us two ways of doing that, either by Congress or the states can propose, and two ways of approving it, either by state convention or by legislative convention vote, your vote. Did they make a mistake? Did they boo-boo and put that second clause for the states? When in fact, they put it in there. There's nothing in the Constitution that describes what an Article V convention is, because they've been having conventions of states, colonies, for 170 years. So they knew how they operated. They knew what they would do. They just took what was obvious and intuitive and continued to use that. So why are we afraid today? That funny word, runaway. Where did that come from, and why is it? What happened? Congress has the opportunity, just like the states, to propose amendments to the Constitution, and they have since 1789 over 12,000 times, of which they've succeeded 33 times, of which you have approved 27 times. Why don't the states have the same rights to do exactly what Congress does every year, producing 50 to 100 proposals to the Constitution? You should have that authority also. The Constitution gives you the authority, the same authority you have over the Electoral College and that other group, ULC, that operates under your authority. Going back in history, those 170 years and all the years since then, we have found in the recorded documents over 650 of the records for each of those conventions, a number of conventions doing a number of things. States, constitutions, amending constitutions. The first constitution was written in Hartford, Connecticut in 1639. It was revised in 1641. So we know how these things work. Just as a point of reference, I wrote a book, I compiled a book, I didn't write it put scholars together to show you the 40 most obvious or notable conventions in our history. But of those 650, here is a copy, and I'll be glad to share it with you, of the 1684 Hartford Convention. And the pages and what they wrote and what they said. These are the kinds of records that are available of that 650 out there. I think we have to ask the question of those that are opposing this, what is your evidence? Where can you show us in history that a runaway has actually happened? There's no evidence of it. So, and what are your credentials for justifying that there has been a runaway or there could be a runaway? It just shows that they're not interested in the history of what made America. These conventions have been going all the way from 1600 through the 2017, and they operate. Everybody in here in engineering or in some other works that deals with procedures, and you set up SOPs, standard operating procedures. There are some standard operating procedures that go along with the convention process, and these evolved in the 1600s and became part of the process, an intuitive process, well into the 1700s. One state, one vote. Each state selects its delegates. Each state decides the number of people that they want to send. Each delegate is commissioned by their state. If, as the case today, we have a number of states who have written delegation limitation acts to protect their states, but in the early years they didn't use those, they didn't need them. And there has been attempts. 1861, somebody stood up and said at the conclusion, after they wrote an amendment to the Constitution, he stood up and said, I want to propose term limits. He was called out of order. It marshals, it takes care of itself. It shepherds itself. Committees are established, and the rules of the convention are established. At the end of the convention, which averages about 12 days in their life, they end, sign, die. I want to challenge you that when somebody brings to you the prospect of a runaway, that you ask them, where's your evidence? Show me where it's happened. Because I can show you where it has not. For my great-grandkids, please help us. Thank you.
Thank you, Mike. You know, one of the most enjoyable things about being actively engaged in this work for quite a long time is we discover there are some issues that completely transcend partisanship. And the debt, the deficits, the things that we're passing forward, and actually the use and application of Article V is a bipartisan effort. I'm so grateful that we've got Sam Fieldman here with us. Sam comes from opposite end of the political spectrum from me, and I got to tell you, I've enjoyed my association with Sam tremendously. To join arms together and work in this effort to save our children, to save the future and what's going on. Sam has twin 11-year-olds?
They'll be 12 in a couple weeks.
12 in a couple of weeks. They came to Utah to visit a little while ago. This is an effort that matters to everyone. There is not a partisan divide to mortgaging our children's future. At this point, Sam is a legal scholar, consultant in Article V convention, Article V application. Tom, do we have any questions at this point that we'd like to field from this part of the panel? And then before we move on to the next speakers. Thank you very much.
We'll be addressing questions in each one of the segments.
All right. So, question. If calling an initial Article V convention is so difficult, should we initiate one with more supported amendment, like a single subject rule? Sam, you want to?
Why not both?
Here, you get the microphone, and we'll get.
I don't agree with Antonin Scalia on very much, but one thing I do agree with him on, when he was asked this question in the 1970s, he said that he advocated for a convention and didn't particularly care what the first issue was that it was on. He said he didn't want it to be on something silly, but there's many issues that are worthy and that a convention should be on. Your support or opposition for one particular convention call should be based on your views on that particular policy. I personally primarily work with an organization called Wolfpack that's trying to get a convention call on fighting the corrupting influence of money in politics. But I recently joined as well to work on this one. There's really no conflict between the two. They're completely separate.
Thank you, Sam. We haven't introduced David yet, but you met David in the plenary breakfast. He'll be speaking in just a few minutes as well. David, go ahead.
The number one argument against a convention of states to propose constitutional amendments is runaway. And as you've heard from Mike, there's no basis for them to make that argument. They just don't want a convention to happen. Here's what's important. There are a number of issues that are worthy of a convention of states to propose a constitutional amendment. Fiscal responsibility is number one. If we don't put our finances in order, nothing else matters. Some people want term limits. Some people want campaign finance. Some people want amendments to control the size and scope of the federal government. A lot of those have intellectual merit. But we have to recognize reality that the number one argument against is runaway, rightly or wrongly. That's reality. So therefore, what we've done is we've said, okay, let's focus on the primary one, fiscal responsibility. And you also heard from Mike, one state, one vote. In 1979, 30 of the 39 were fiscal responsibility only. In 1983, which was the high watermark, 32 of 40 were fiscal responsibility only. That means a meaningful majority of the applications were fiscal responsibility only. You overlay that to current control of the state legislatures, and the bottom line is that is a safeguard that will prevent a runaway, because a meaningful majority of the applications are for fiscal responsibility only, and therefore the president of the convention will be able to say out of order. You are out of order. So let's prove the concept. Let's do the most important thing first, but the states are going to have to sue to get it done, I can tell you that. And then we can end up using it for other things. One last thing. The Convention of States ought to be with us. They'll never get to 34. They'll never get to 34 because they want to do three things at once, which flies in the face of the primary argument. And so what we're trying to do is to get them to be with us to say, hey, let's prove the concept. Let's do first things first, and then we're with you to try to be able to get some other things. And I also, frankly, support a meaningful amendment on campaign finance, which is a different subject. Thank you.
Yeah, David Bidoff, you wanted to weigh in on this as well? Yeah.
So ALEC has three model policies that help with this. I'm sorry.
Get that right there.
ALEC has three model policies, and one of them is the Delegate Limitation Act. There are 14 states that have passed this act. In about half the cases, there are criminal penalties. Once you have commissioned your delegates, and there are 28 states that have also ALEC model policies, which are applications for a convention for proposing a fiscal responsibility amendment. So once you have commissioned your delegates, you can have them take an oath. If they go outside the subject matter that you have delegated for them to address, then they can be recalled, their vote can be nullified, and you can bring them home and charge them with civil and criminal penalties. And this is very much like what you do with faithless electoral college people. So that's one. Number two, remember what was said. The convention is run one state, one vote. Guess how many states are run by Republican legislatures? How many? Who's got the number? 35. 30 states are run, legislatures are controlled by Republicans. They will control this convention. 28 of those states, we're only missing 2 states that don't already have a binding fiscal responsibility balanced budget amendment application. And that's Montana and Idaho, and I think we're going to get them on board.
So I had the opportunity a couple summers ago. We were doing an Article V Academy in Denver, and I was presenting with Carmine Gentile, Representative Gentile from Massachusetts, and he's easily as far left as I would be considered right. And impromptu, I asked him, I said, Carmine, what would you say to some of my friends back home that are concerned if we convened an Article V convention on balanced budget fiscal responsibility that someone would introduce doing away with the Second Amendment? And spontaneously, he just laughed right out loud. Just burst out laughing. He said, it would never happen. It's outside the scope. It's outside the scope. It would be improper. It could never come to the floor. And that's the nature of how this works. But I think even more so on the protection from that, if that were to happen, how many red states would just get up and walk out, that there wouldn't even be a quorum? Right? I mean, those are the kinds of things that if it goes outside the scope, beyond the Delegate Limitation Act, beyond someone going to court to challenge it within the scope, beyond the presiding officer ruling it outside the scope, beyond the body itself bringing it up that it would be outside the scope, enough states could just simply walk out and a quorum would be destroyed. So we've got it. We're going to run behind time.
Right. Follow-up question.
Okay. I just want you to know it's cutting into your time.
I don't have any time. Opponents justify the runaway argument by saying the Constitution actually evolved from a runaway when the states met after the Articles of Confederation. That was not a convention to propose amendments. We are talking about Article V, which is very, very clear. It is not a constitutional convention. It is a convention to propose one or more amendments.
Yeah, that one always gets me as well, too. You have people that will stand up and say, we love the Constitution so much that we're afraid if you use the Constitution, you'll destroy the Constitution because you're not James Madison, you're not George Washington, but oh, by the way, their first act was fraud because they went outside the scope and they had a runaway convention. I would point you to Michael Ferris did a Harvard Law Review article on the subject, and he went back to all of the calls of the states. And the actual language of the call, it was to make the Constitution was like appropriate to the exigencies of the nation. Their call was sufficient to do what they needed to do. And then they sent it back to Congress, and Congress sent it out to the people. So to suggest that that was a runaway defies a lot of logic and a lot of steps, the language of the call, and for me, it denigrates men that I revere as raised up by God to do something that was very singular in the history of the world. So interesting arguments, but the Harvard Law Review article by Michael Ferris, I would point you to that. We have the opportunity to hear from my good friend Sam Fieldman, who again, we come at this from nearly politically opposite directions. This is an extremely brilliant Article V scholar that we can join arms and get together. This is not a partisan issue. So Sam Fieldman.
Thank you, Ken, and thank you, everybody. Not too long ago, I was at the 50th anniversary gala for ALEC, and they read a quote there, which I was surprised to see was the exact same quote that's in the new book by Cenk Uygur, Justice is Coming. The issue today is the same as it has been throughout all history, whether man shall be allowed to govern himself or be ruled by a small elite. As I've listed several times, I have very different views from a lot of people in this room. So personally, I found it ironic when the next thing that was said was thanking the corporate donors of ALEC for coming to influence the politicians that were in the room, which is definitely a paraphrase. That's not the way they put it. So you may ask, why am I here at ALEC? My journey here today was different from a lot of people that are in the room. Certainly, Ken has been a great ally and supporter in the other group that I work with, Wolfpack, trying to get money out of politics. But in general, I disagree with quite a few people. I'm here between very conservative Ken Ivory, and coming up right after me is very conservative Ken Cuccinelli. To be perfectly honest, I find some of the views that they hold to be draconian and go to the very core of civil rights, and they would say equally harsh things about some of the views that I have, and that's okay. The beautiful thing about our Constitution is that in order to amend it, you need to have broad consensus across people who cannot possibly work together on any other issue but the issue that you're actually amending. Without that enormous bar for consensus, the Founding Fathers designed it so that you simply cannot amend the Constitution. So my journey here started with two things. My twin girls, as Ken said, Hannah and Ginny, they're about to turn 12 in a couple of weeks. And when I was a young lawyer, I wanted to make sure that they were growing up in a world, as Jefferson said, where they actually had self-determination rather than one that was ruled by the few elites. And I looked into the Constitution. I found the Article V convention process. And when Wolfpack was formed, I joined it on the day that it launched. Through Wolfpack, I've studied and I've been studying Article V now for the past 12 years. And in 2016, I was asked to do some research on what do we do if Congress just says no. If we get to 34 states and Congress says, we don't believe that there's 34, we're just gonna ignore the whole thing and not call a convention. And the research that I did basically said that the states do have standing to force Congress to call a convention, and Ken Cuccinelli is going to go through some of the technical legal aspects of how that works. But I didn't really think this was a plan for something down the line, pretty far in the future, because Wolfpack only had 5 convention calls at the time. There were a few that were plenary that could be used for anything. There were some that some people were saying could be used for anything, and when I read them, that's just not what they said. So I didn't really put much stock in that except for something pretty far down the line until I read a news article about David Bidoff, and he was claiming that there were more than 34 calls by 1979 already for Article V convention specifically on the issue of fiscal responsibility. And I called him up the next day, and I've been working with him just in general ever since. And the reason why I wanted to work with him on that, 100% of peer-reviewed scholars agree on one thing about Article V. They agree that there's no way that a new limited convention call could possibly lead to an amendment on any other topic. And they agree about that even though they disagree on many of the little details. They agree on that because either we already have enough convention calls, so a new convention call is meaningless, or because a convention can be limited and therefore a new convention call would have no impact on any other topic. But I didn't think, when I had looked through the record, because I was mainly focusing on a different issue, that we had 34 on the issue of fiscal responsibility. But I worked with him because I wanted to make sure that if it went to court, that there was an actual decision on the merits. And that's what I had been studying since 2016, was how to get the decision on the merits, not one that gets thrown out on a technicality. Because a decision on the merits will lead to a lot more certainty rather than just relying on the few things the scholars all agree on and then the things that are a majority and a minority view. We would get real court decisions and real certainty. And regardless of the outcome of the lawsuit, as long as it reaches a decision on the merits, that would benefit everybody who wants to use this tool, and really everyone in the country. It would benefit people who are afraid of this tool also by alleviating those fears. But then they brought me on as a consultant. I'm a consultant. I'm an independent contractor for Wolfpack, and they brought me on as a client as well, as a contractor for them as well, to look into this more. And part of the deal that I made with them was that I'm not going to give any opinions that I don't personally believe, which explains why I gave my opinion on what was going on at ALEC earlier, and not the opinion that ALEC would probably prefer that I give. But what I found when I looked into it, initially I was skeptical, like I said, that there were actually 34 calls on a single issue. But when I looked into it more closely and started to actually count the individual calls, what I found is the map that you're looking at right there. But this is an animation of the calls through time. The blue states there are calls that are plenary, and then you can see some orange states coming in. Those are calls that are arguably plenary. Those are going to end up not being super important anyway. A lot of those were calls that may be for a different issue, but arguably are plenary. The red calls that are coming in there are specifically for fiscal responsibility, and the green ones are calls that have specific amendment language in them, but also specifically say that the specific amendment language is just a suggestion and that they're open to anything that's substantially similar to that concept. And there is scholarly research. The Congressional Research Service, quoting a report by Congress, in fact, partially authored by Chuck Schumer when he was a congressman, argued that substantially similar language is sufficient to be counted as a plenary call, or to be counted as a call that is not limited to the specific language. So if you count up these calls, what you find is you actually do get enough. Now, one of the issues that we were having, and one of the reasons they brought me on board, when they tried to ask the archivist to count, the archivist said it would cost how many millions of dollars?
$18 million in 6 years to find the original application since the beginning of their country.
Yeah, so I laughed when I saw that number. Here they are.
Tell them how you got
It cost me about $1,000 in a subscription to Hein Online and a few months. This is $275. There's about 450. You may have seen the one, a lot of you might be familiar with the article5library.org. It's an excellent source, and it is very good. It is not perfect. It relies on the congressional record, which has some errors. That's not what this source is. These are the original documents from the states themselves. With certifications, those certifications are printed right in many cases, in the state session laws books. And I've got the state session laws books from Hein online, but you can find physical copies in the Library of Congress, because Congress has had these the entire time. But if you want to, but when you synthesize it down to just the relevant ones, that's what this is. This is the strongest application. This is 35 different states, transcribed. It'll be at our table out there. Transcribed the exact text of 35 different resolutions from 35 different states. As you saw as things went through, there were many more that we're not using as part of this application that could qualify. This is the strongest set of 35, just to simplify things. And when I was looking through it, I found with this, it's beyond question that as of probably 1979 and certainly by 1983, the Article V convention call was triggered. And once the convention call is triggered, it's like a contract, like the ringing of a bell. That means that the right to sue the right to a convention has vested in the states and vested in the state legislatures, and that triggers their right to sue to force a convention. And with that, Ken Cuccinelli is going to talk about in more detail about how that works. Go ahead, Ken.
Thanks, Sam. I appreciate it. Can you all hear me all right?
Yes. Yes.
Okay. You may hear some grandchildren in the background. That's we'll just call that a reminder of the reason for this. But
That's the theme of the day today, Ken.
yeah, I have little doubt. I know it's a theme we hold near and dear at FFSF. So Congress is clearly resisting calling a convention in order to avoid limiting its own power. This is something foreseen by the founders, that the federal government would resist state authority. And it's part of the very reason that Article V exists, is so that the states could curb the federal government's power. And specifically, this would be congressional power. And Texas Representative Jody Arrington, of course, has HCR 24, which would call the convention for the purpose of amending the Constitution for a balanced budget or some sort of fiscal responsibility amendment. I'm sure you are all aware of that at this point. And but the fact that one member has proposed it is not moving it. Congress as a body is resisting this undertaking. And so what do we do about it? Well, we've passed the 2/3 threshold, as you heard from Sam and others. You saw it on Sam's map there. And thus, Congress must call the convention for amendment. And Hamilton addressed this directly in the Federalist Papers. This is not discretionary on the part of Congress. This is a requirement that is, I'll call it ministerial in nature. They don't have discretion about whether or not to do it. And the rights of states that are being denied, your state's rights are being denied, you can seek judicial relief. Now, this has never happened before. There are several things we could say this has never happened before. One of them is that the states have never sued Congress before, at least not successfully. And one of the great legal concerns is, will the court sustain a lawsuit against Congress? And obviously, we hope that they will. And the best argument for doing so is the counter to the usual. And I don't want to take you all to law school here. Many of you have wisely chosen not to go that route. I don't want to spoil it for you. But the courts respect the executive branch and the legislative branch as co-equal branches of government. And the courts are very loath to invade their areas of responsibility, exclusive areas of responsibility. So thus you see that reflected also in the Constitution and things like the speech and debate clause. But the reason that the courts might reasonably be expected to maintain this lawsuit and reach the merits of the case, as Sam had noted, is that if they do not do so, then they will be disparaging an also equal constitutional player, the states, who are and always have been deemed sovereign and the creators of the federal government. And given that the contest here is between the states and the Congress specifically, we expect that the courts will be willing to entertain this case and reach the merits of the case. Sam, just checking with you. Can everybody still hear me okay?
Yes, yes.
Okay. All right. It's hard for me to perceive that end. So how do we go about doing this? Well, we get a few of you states together, your legal representatives, whether it's your attorney general, whether it's your governor. I know Ken Ivory is there. In Utah, the legislature appears prepared to go forward. That is unusual and rare. So I know you're a legislator and you want to do things and you're thinking, oh, could I do that? Well, make sure that there's some methodology by which you could do that before you rely on your own legislature, as opposed to trying to get your attorney general or governor as a plaintiff. And we'd like to talk to whoever that potential plaintiff is about a declaratory judgment action, about the states suing the Congress and seeking the court to rule that, yes, the 2/3 threshold has been met and enter a declaratory judgment to that effect, finding that that exists, and either ordering Congress to fulfill its responsibility with the backstop that if it doesn't, it's in contempt of court, or just go ahead and order the convention for the purposes of drafting an amendment. And we need states to join us to do that. This is not something that the other states that might be reluctant today can back out of. I will stay with Sam's ringing of a bell analogy, and I'll use a crime as a similar consideration. So if I catch you outside the hotel and rob you of your wallet today, and I come back tomorrow and give you your wallet back because I feel badly about having done that, well, that's very nice, but it doesn't change the fact that a robbery occurred. It does not undo the occurrence of the crime. It may mitigate the harm of the crime, but it doesn't undo the fact that a crime was committed. And as a former attorney general, former prosecutor, we would say you cannot unring that bell. Similarly, once the states pass the 2/3 threshold, that bell cannot be unrung. The Congress has a duty. It has not yet fulfilled that duty. Now, some of you may say, well, but that happened in 1979, and that's true. We would say the conditions were met for about the next 20 years or so. I won't dwell on how long it was. But you'll recall that in 1992, the 27th Amendment was ratified by Michigan, the legislature of Michigan, and thus it became part of the Constitution 203 years after it was introduced by James Madison. And no one has questioned the viability of the 27th Amendment as the most recent part of the Constitution. It still has that sort of new Constitution smell about it. That's also very nice. But that kind of duration is similar to the length of time for some of the plenary calls, for example, my home state of Virginia, just by way of example. And so that time passage in the constitutional context has not previously been held to a stop, to use a judicial word, estoppel, to stop a plaintiff from proceeding. I have a 27th Amendment case now, and the existence of the 27th Amendment is not giving us any trouble. They're also against the House of Representatives, though not as a body. And they didn't even attempt to defend by saying there is no 27th Amendment. So that passage of time, we don't view as undoing the opportunity to bring this case forward. And what we need now is you all to help us recruit your states, your attorneys general, your governors, and in some cases, maybe your legislative bodies, to serve as plaintiffs in a declaratory judgment action by the states against the United States Congress, seeking an order that the Convention of States be called for the purpose of amending the Constitution and adding a fiscal responsibility amendment to it. And that's what we need your help for. And given the technical gulf here of time and space, I'm going to leave Q&A to my colleague, Sam Feldman, and appreciate him being there in person and the rest of our team. I saw David there, and I know we've got others, and appreciate y'all's support at ALEC over a long period of time for balancing the budget and preserving our country from financially going down the drain. So thank you all very much. It's been a pleasure to be with you again.
Thank you, Ken. Now, I will note, and you've heard before, if you get 2 or 3 lawyers in a room and you ask for opinions, you'll get at least 5 opinions, right, out of that. In Article 5, if we look to Article 5, it says, Congress, whenever 2/3 of both houses shall deem necessary, or on the application of the legislatures of 2/3 of the states, shall call a convention for proposing amendments. In Utah, in our legal team, we interpret that to mean that the governor has very little role. The attorney general has very little role, that the legislature, and in fact, we got that opinion from our attorney general as well, that this is the duty, this is the constitutional purview jurisdiction, if you will, of the legislature to move that forward. Ken, while you're still here, and I don't know how long we're going to have you with us, is he still on? While we still have you, Ken, we've got a question.
Really. Maybe.
We may have lost him. If not, we'll work it here. It says declaratory judgment. Which court would have original jurisdiction? What appeals may come from Congress? What would the expected timeline be? And he's gone then.
Okay.
I think in the discussions that we've had, there are actions where the Supreme Court can exercise original jurisdiction, that the case just goes straight to the Supreme Court. This is of the kinds of cases that could go directly to the Supreme Court. Clearly, when there are states suing each other, that goes directly to the Supreme Court. In something like this, where you have a state suing Congress to simply exercise its role under the Constitution to count, archive, if there are 34, then call, there's a very good argument that there would be original jurisdiction at the Supreme Court. Timelines, what we would expect from Congress. What we would expect from Congress is more of the same, right? Congress would be expected to continue to delay and push and except that, what we heard from Speaker Johnson, that could be a new opportunity. There's actually been conversations with Speaker Johnson. I don't know if any of you want to take that there have been conversations into the Speaker and the leadership in the House that they're very favorable. And certainly we heard from Congressman Arrington this morning and from Speaker Johnson.
We should talk about actually getting these documents into the official record.
Yeah, that's.
Go ahead.
I mean,
You want to take that, Sam?
Yeah, I'll point out there are things that need to be done to engage Congress to try this. Things like sending a letter demanding action and trying to get these documents into the official record as well. All of these things are useful and need to be done. Ultimately, we don't really expect Congress to actually call the convention or take really meaningful action. It is helpful that actually both the Speaker of the House, Mike Johnson, and the Senate Majority Leader, Chuck Schumer, have both publicly studied. They both studied Article V. They're both well aware of it. As I said, the reports by Congress from the 1990s and 1980s, Chuck Schumer worked on those, and Mike Johnson has studied the issue extensively as well. But I don't expect either one of them will get majority votes in either the House or the Senate to pass a convention call, just because of the nature of how Congress works. So while I would love that to happen, what I expect to happen is that the lawsuit will need to actually be filed and gone through with. And if you want to talk about some of the details of legal strategy, that's a thing that we'd love to talk to people about behind the scenes, but certainly are not going to talk about it too much publicly.
Yeah. How many of you have heard if we just did away with the 17th Amendment, all our wildest dreams would come true? Right? Do you know how the 17th Amendment came about? It actually came from the states. And the states began filing applications to change the legislatures electing the senators, because the only thing anyone was asking about when state legislators were running for office was, who are you going to pick for Senate? And it bogged down the functions of government in many of the states, that they said, we don't want this power. And they started making applications, and there were others that wanted to have the Senate be popularly elected. And I will say that Utah was one of the only states that not only did not apply for the 17th Amendment, we rejected it and said that we didn't think that that was a good idea or constitutional. But
Ken, let me respond.
but if I could just a second. So what typically happens in these is, as the states continue to move forward, Congress doesn't typically want to lose control. And if the states move on the action, they then will typically propose an amendment to move things forward. So that's how we've gotten the 27 amendments that we have now.
Let me give you the bottom line. McConnell is against a convention of states for any amendment. Schumer has not gone on the record, but my gut feeling is he's probably in the same thing. The Speaker, Johnson, is for a convention of states to propose an amendment. I don't know where the Democratic leader is.
Pelosi's
And what I,
against.
well, Pelosi's not the Democratic leader. But secondly, the most important thing, and I won't mention who said this, if you want this to happen, you have to sue Congress. I won't mention who said, this is a very, very high person in the Congress who said, if you want this to happen, you need to sue Congress.
All right, this is one of my favorite questions. How will amendments to the Constitution that result from a convention of states prevent a government that is currently willing to violate the constitutional guardrails for what they believe is doing good from simply violating the new guardrails? Go ahead. This is one of my favorite questions. Go ahead, David.
You've got to have a number. It's the only thing that cannot be changed. And so the two constitutions that have numbers in them, one of them is Colorado with the Tabor Amendment. It has a number that the state cannot grow faster at any level than inflation plus population. It's a number. It can be audited. The same thing is true with Switzerland. They put a number into the Constitution. Basically, the government spending couldn't grow faster than the paychecks of the people of Switzerland. It's a number. You start the budget year. This is the number that you cannot appropriate more money than, or you're in violation of the Constitution. It is not what is the definition of is. It's a number. It's auditable. It could be independently audited. And here is a very interesting idea from Warren Buffett. He said, I can fix the nation's debt in 30 seconds. How would you do that? We've changed the version a little bit, but if Congress in a calendar year exceeded the spending growth limit in the Constitution, no member of the majority party is eligible for re-election. That's Warren Buffett.
Yeah, I mean, those are guardrails. The reason you have a convention is the states get together and we discuss how to prevent that very thing. and you discuss what the amendment would look like to make sure that it was enforceable and enforced. And I would note that of the amendments that have been passed, we've got women are voting, we've got alcohol was prohibited and then brought back, which also speaks to runaway and other concerns. If we do an amendment and it's not quite right, and we've dusted that tool off to where we meet in convention regularly and something is not quite right, how many of you get legislation absolutely perfect the first time you go through in your states, right? Most of what we got a couple, right? Most of what we do, right? Most of what we do is we're refining and amending and getting it more and more right. Now, clearly in a constitutional amendment, you don't want to, you want to make that very precise, but if we dust that tool off, like the 18th Amendment and the 21st Amendment, 18th Amendment was prohibition. It didn't work out for the nation. And so then they met with the 21st Amendment and repealed that. So once we dust that tool off, we've got the opportunity to fix it. Utah was the final state on the repeal. That's right, which was a bit surprising. Do you want to take this a little bit as well?
I just want to point out real quick, women should have been allowed to vote under the Equal Protection Clause of the 14th Amendment. They were violating the Constitution, according to quite a few people at that time, and I agree with that position. They passed an amendment and they stopped violating the Constitution, and part of why they did is because the overwhelming support required to actually get an amendment to the Constitution is part of the enforcement mechanism of the people on their elected officials that makes it much harder for them to keep violating the Constitution.
Yeah, I think that's right.
Madison called it an explanatory amendment when he was arguing for the use of Article V.
When you go through the process of the people proposing and ratifying amendments to the Constitution, it is an act of the people. And the likelihood of that being honored, we've seen all of the amendments honored that we have in the Constitution now. Are there any limits on Article V resolutions? Is it likely resolutions are thrown out for being too old? You want to take that?
Yeah. Just to reiterate what Ken said, if you look at some of the older scholarship on this, that was an open question. The scholarship on that has fundamentally changed with the passage of the 27th Amendment. What we found before then, people looked at some of the Supreme Court cases that said that it would be reasonable for Congress to set a 7-year limit on ratification, and Congress can set a reasonable limit. And they looked at that and said, well, maybe that 7-year limit also applies to an Article V convention. What became extremely clear when an amendment that was proposed 202 years before it was ratified, that if no limit is placed, then there is no limit. It's just simply not written into it.
Yeah, they often in con law or contract law in law school, they say that the offeror is the master of their offer. You get to set the terms. And as states, when we do applications under Article V, we can set a time limit. And so if we do a resolution that says we're making this application for an Article V convention on, fiscal responsibility, but the application is only good for 10 years. Or that's the state's opportunity and ability. And so if they don't state a time, like the 27th Amendment, that stays out and it's there until it's rescinded, because the state then always has the power to rescind. So if a state believes their application is too old, then they can simply take action and rescind the applications they have outstanding.
There is a subtler point there as well, which I think is particularly important in this situation. With the 27th Amendment, the bulk of the ratifications were within about 14 years of the time it was actually ratified, and that was part of one concerted effort by one guy in Texas who just tried to get that through, and that combined with a handful of much older calls, and those states were aware of their older calls being on the books, so that really shows a consensus in the country. And what we've seen here is basically the same thing. We've got fewer older calls here than we had for the 27th Amendment, and we've also got a lot more convention calls a lot closer to that time period of 1979 or 83 than we did. Most of them were like 77, 78, 79 as part of one concerted effort. So it really demonstrates the consensus, which is another argument about how Article 5 works, is the consensus view. And on that view, the same conclusion applies.
Ken, I believe the numbers were met from 1979 to 1998. So we're not talking about, gee, we hit it, a number of years ago and we lost it quickly. That's not the case. There's no statute of limitations here, okay? Unless the application specifically has an expiration date. As you may recall, in addition to, the 27th Amendment, which didn't get ratified until over 200 years. The Equal Rights Amendment actually had a date that said you had to ratify by a certain time or else it wasn't effective. That's not the case here. There is a case. It just needs to be brought sooner rather than later.
Yeah, there's a couple questions that are related. Have any resolutions been counted? And if so, what's the number? And David, I think David and Sam have dealt with the application, but I don't know. I mean, has Congress actually ever counted and delivered a count on the applications of the states?
No. Congress recently, the House Judiciary Committee recently asked the House Clerk to start pulling these together, and we're doing a number of things to provide documentation to the House Judiciary Committee and evidential matter, but they've never counted.
So this question, there are two questions that basically go to the same thing. How do we prevent Congress from running the show? What is the responsibility of Congress? And that's a really, it's a great question. Many people have said, if there's the applications, Congress will just decide what they want to do. Congress will dictate the terms. Congress will run the convention anyway. If you look at the Constitution, the language out of it, it simply says, Congress shall call the convention for proposing amendments. There's actually case law that deals with the nature of that duty. They call it a ministerial duty, that once we get 34 on, arguably 34 on the same subject, Congress's duty is simply to name the time and place for a convention. And that's it. And then the convention, once the states convene in a convention and they start and they gavel in the convention, that's its own Congress. That becomes the definition of a Congress, that the states are meeting in convention to address problems among the states. And so the states will, first order of business, they'll deal with their own rules, they'll elect presiding officers, and then the states will look at the various applications and determine if those applications aggregate or not, and look at if they're on the same subject. Then they'll approve a set of rules for the convention and have any number of committees they may need to then hear evidence and look at the terms and the nature of the call. But the way that the legal action is being presented, it goes to that the states, once there is colorable calls on the same subject, Congress calls the convention, the states then determine if the applications aggregate and determine the rules and where they go from there. As we're getting close to the end of the time, I've got a couple of questions here that I want to throw out to some of the panelists here. They said, this is the best Supreme Court in our lifetime. What do you, how do you gauge the nature of the action, the timing, and how we move forward from here? David, do you want to take that question?
I don't think it should come as a surprise. I disagree that this is the best Supreme Court we've had in quite some time. However, we've seen in 2020 a unanimous decision on the ability to limit on the ability of states to limit what their electors do in the Electoral College, and that was decided based on language that has been used in Article V ratification conventions before, when we ratified the 21st Amendment. So regardless of your view of any particular justice, they seem to be particularly good on this issue with that unanimous decision there. And as well, I do agree that for this particular question, even though I disagree with them on many other things, it is a particularly good court.
Question says, Congress says it typically cannot be sued. Why is this different?
Oh, yeah. Because this is not a legislative act of Congress. Congress cannot be sued. Congress has legislative immunity, but this is not a legislative act. Just like recently, Congressman Bowman was taken to court for opening a fire door, even though it was in the congressional building on his way to a congressional hearing. That was not a congressional act. This as well, and there's Supreme Court precedent dealing with the notion that an article, Dillon v. Gloss, for example, dealing with the notion that the things dealing with amending the Constitution are not necessarily congressional, or are not necessarily legislative acts, and so here that wouldn't apply. The one thing that, or one of few things that scholars have been really very vocal on, and one of the few things that their founders were particularly vocal on Article V, was that it's a ministerial duty and Congress does not have any discretion. And when that's the case, that means it can be enforced.
So, David, as we're coming close to the end of our time here, would you like to, as the grandfather that has been sustaining this action, I have to tell you, David Bidoff and his wife, out of their own lives, fortune, and sacred honor, have been moving this effort forward for decades. And the fact that we have support as states, the fact that we have legal support, that we have factual support and experts that you've seen is because of David and his wife simply moving forward their treasure to make this happen. So, David, would you like to take a few minutes?
Just a couple. So this is about our granddaughters, 19 and 21. And about 10 years ago, I asked them, what do you think of the idea that your parents and your grandparents are passing on to you this enormous debt, the interest on which, by the time you get your first job and you get your first paycheck, they're going to take out 7.5%. They're going to say it's for Social Security, but guess what? It's actually going to 100% going to go to pay the interest on the national debt. Guess what they said? Grandpa, that's not fair. So, spoiler alert. So I have a question. How many of you could call up your U.S. Senator or your rep, your congressional delegation? All right. I want you to call them up and say, we passed an application back 5 years ago. What's the count on that? You know what it's going to say? I have no idea. You know why? They have never properly filed, certified, made sure that it was authentic application, which has the power of a constitutional amendment in it, basically. They've never properly stored them. They put them in a box by committee, by year. And in 2017, a member of the Congress said, well, let's have a Records Transparency Act. We simply want to get a physical photographic copy of the document and post it online. We're not going to count them. We're not going to say they're valid. We're going to say they're purported. So we're not going to count them. And so they went to the archivist and say, how long would it take you to get these physical certificates, basically applications? And they came back and they said it would take 6 years and $18 million, and we wouldn't find them all. This is intentional. There is a law on the books for the counting of resolutions ratifying every amendment, including the 27th. So they had a drawer with those resolutions. And when the archivist got the 27th, or when the archivist got the 38th resolution, he simply went to the floor of the Senate and said, you've got yourself a brand new amendment. And they were stunned. They had no idea it was coming. In fact, they kind of, it was about their paycheck, and they kind of was, is there anything we can do? And they said, no, because it's a ministerial duty. This is a deliberate act or inaction on the part of Congress. And here's the damage it's done to our country, and it's breathtaking. Because using the same aggregation that the best scholars that are out there on counting these things say that we hit it in 79 for a fiscal responsibility amendment. The same library, you can go to it. You can go to it right now. In fact, we've got a QR code. We'll give you a copy of it. You can go to it yourself. And you can see that it's been hit 5 times in our nation history, where more than 2/3 of the states had put in an application on a single subject or on any subject. And it was in 1908. And this was after the Cosmopolitan magazine came out with a headline, "The Treason of the Senate." It was being corrupted. Senators were going to jail. Legislatures were being corrupted. And the people were outraged. And there was article after article. Actually, there were 11 articles on the treason of the Senate. In that time period, in between 1900 and about 1913 or 1912, there were 61 applications from the states. In addition to the ones that had pre-existed on any subject, they basically didn't call it. And for the next many years, they just kept fighting, and they basically bypassed the constitutional process altogether. And one state at a time, they came up with a way to actually effectively get the direct elections of senators once. In 1943, they wanted to repeal the income tax. They wanted to repeal the income tax, and 2/3 of the states agreed. And they wanted to replace it with something like a income tax with a 25% cap. Then they did it again in 1965 with apportionment. Then they did it in 79 for the fiscal responsibility amendment. That's all I got to say. There's only one way to fix this. We've got to sue these people. And if you're not mad as hell, then I need to talk to you some more, because this should infuriate the legislators. They've cut you off from your equal authority to propose amendments. They've done it intentionally, and we've got to stop them with a lawsuit. Thank you.
Just wanted to introduce myself. My name's Tom Llewellyn. I'm the editor of the Fix the Debt Gazette. Our website is stopinflating.us for all the background that you need to follow through with these. The PCC gentleman, Bruce Lee, is there to help advise and talk about how you can participate in this cross-communication resource that's also going to be able to help oversee and coordinate an upcoming convention. The tragedy, this is the largest case of gross negligence of the constitutional duty of Congress ever. These are your applications. We have hundreds of times of opportunities for them to have acknowledged and even said that yes, we got it, and we thank you, we're keeping track, and you're number 32. We have seen where this is now proven to be valid, even to some skeptics among us, as to whether the count would be valid. And now with the fact that we're in literally a death spiral of debt, you see more and more articles talking about how the interest on the debt is compounding the problem, having to borrow more money to pay for the interest on the debt that we've already borrowed. That's a death spiral that is very difficult to come out of unless we take action. Action is what we're asking for right now with every one of you. We had 70 people in this room. We have a need to move these type of demand resolutions forward right away. West Virginia is pursuing a demand resolution as we speak to be able to compel Congress to follow the law or be sued or have the states take additional action. So we are in a position to be able to really announce to the world that it is done and we now have states ready to rule. We're looking for you to join the effort. Thank you very much.
I just have one last question. Are you relevant? Are you relevant in our government? In the United States of America, are you relevant? Congress has ignored the applications of the states. If you remember when the Obamacare legislation was being considered, and reporters asked Speaker Pelosi at the time, they said, "Madam Speaker, where do you have the authority to do this?" Do you remember what she said? She simply said, "Are you serious? Are you serious? Where do we have the authority?" We're serious. So the authority lies with you. But if Congress ignores the constitutional authority of the states, we're not relevant unless we enforce the power of the Constitution. Congress is not going to enforce the rights of the states. They're not going to enforce the powers of the states. That's up to you. You have a copy of the letter that Utah presented from our Senate president and our speaker, inviting you to join Utah with the legal action that has been prepared by these gentlemen at their own expense. They have some of the top constitutional lawyers, Supreme Court lawyers of our age that have prepared the draft legal action for us to consider. We're looking for other states to join with us that we are relevant in enforcing our own constitutional powers and duties. And I'll just remind you what we talked about in the plenary breakfast. When they put Article V into the Constitution, they did it because they said that the ultimate sovereign power doesn't rest with the federal government. The ultimate sovereign power of altering and amending the Constitution, that rests with you. And so if we're going to watch Washington, we don't have the liberty, knowing what we know, to point fingers at Washington and say it's their fault, it's their problem. I just end with this. My father was a pilot. He had a private plane. It was a Cessna 182 RG. I thought it was really cool. And we would fly from Salt Lake to Phoenix all the time. He had businesses in both places. And in this little plane, and you cross the Grand Canyon in the little plane, it was a little daunting. And I always kind of, was a little concerned about that. But my dad would always say, at any given time, he'd say, "Okay, your engines just went out. Where are you going to land?" And we'd look around and look at how much glide we had and find spots. And my father used to always say, he said, "Pilots perish when they panic. Pilots perish when they panic. If they fly the plane until it stops, pilots walk away almost 95, 99% of the time. It's not time to panic. It's not time to give up. It's not time to look for someone else to come to the rescue. It's time for us in the states that have this sovereign power to fly this plane. Hopefully it never stops, but on our watch, that duty is ours. So I hope you will join Utah, take advantage of the great work that these gentlemen have put together for all of us. And please see us after at the table. And if you are at all interested, let's carry this conversation forward. And if we don't, then the debt accrues on our watch, and it accrues on our standing, because we have all of the power to do this. Thank you for taking the time to be here. Please take this letter, take it back to your states, and let's fix this nation, that it doesn't end on our children. Thank you very much.